Hey everyone, it's Christopher Adamson. Thanks for tuning in for another episode of the It's Personal podcast. We actually shot this episode back in April, but the focus is still very much relevant. It's about employees and employers and how we can create and build safer workplaces for everybody. So hope you guys enjoy the episode. Thanks for tuning in. We're back with another episode of the It's Personal podcast. I'm Christopher Adamson.
This is personal injury. It is personal.
Okay, so I think we need a couple episode disclaimers on this one.
Okay.
The first one is that I am not a lawyer.
I am. Not in the state of New York.
Not in the state of New York. In which it ends with us, Justin Baldoni, a Blake Lively trial, will be happening because the film, I'm assuming because the film took place there, production was there. However, I don't know if the parties, being a Delaware company and California residents, I don't know how that all plays a role in being a New York trial, but I don't know.
In California law, generally you file where the incident occurred or where the action occurred. So
Well, then that's
all this occurred in New York because that's where they shot. Then I'm sure that's part of the reason, at least, why they filed there.
So the other episode disclaimers is that I think there's been a lot of talk about this case. And I think for various reasons that I want to cover up front, because the purpose of this is not necessarily like a pop culture deep dive to, weigh in on whether or not we like Blake Lively or Justin Baldoni, because ultimately we don't know them and that's not really relevant. But that does seem to be the biggest piece of this discourse, no matter how much people dress it up with taking a legal, I've seen a lot of TikTok lawyers cover this for the purposes, I think, mostly of maligning either or his character.
Yeah.
Which is going to happen in March when this trial finally happens, if they don't settle prior. But I think, with a case like this, and the reason that I was interested in hearing your thoughts is because you come from employment law.
Yeah.
And this begins ultimately with a hostile work environment claim that I want to go through, because I think it kind of speaks to very globally something I think a lot of women deal with, but a lot of people that don't feel safe at work, maybe I think the toxicity around this hasn't helped people feel empowered to come forward. So I do think it's important to kind of go through the complexity of the complaint and how that was handled, and sort of what the film shoot, how that adds a dimension to this that's maybe making it harder for people to maybe take seriously. Or maybe they're taking it too seriously. So I think there's a lot of pieces of this that make it a sticky case to cover, which, while in some ways that could have meant we should not have touched it, I don't know. I think calm, level-headed minds approaching something like this is always cool. From the Justin Baldoni's camp of it, right? I'm interested to also hear your thoughts on defamation, invasion of privacy. These are very grandiose countersuits, which just from brief research seems to be somewhat normal in asking for $400 million in return, because you're not necessarily going to receive that. But it also seems like a very a 180 response to something that a lot of people deal with, which is a hostile work environment. So that's kind of where I want to just lay those disclaimers. Chris, do you have any disclaimers to lay down?
My disclaimer is I'm not the pop culture expert, so Lauren's going to fill me in as we go along. We're going to go through the timeline, so I'll comment where appropriate. As far as that number goes, 400 million, we could talk about that when we kind of get to that section, but there's probably some rhyme or reason to that, I would imagine, which, I have some thoughts on that. But other than that, as I said, I'm not an attorney in New York. I am an attorney in California, also Texas. So,
hey.
Yeah.
Or yeehaw.
Yeehaw.
Okay, so let's back it up for anybody that doesn't really know what this case is, or cases. There are now multiple lawsuits. So a movie, It Ends With Us, which is based off this Colleen Hoover book, about domestic violence. So a very serious topic. Was the rights were bought by Justin Baldoni's production company, and Justin Baldoni is an actor and a director. He was on the CW show Jane the Virgin, great show. And Blake Lively, I'm sure you do know.
Yeah.
Actor, Gossip Girl, very famous acting family, Ed Lively, etc. Married to Ryan Reynolds. And so obviously she signed on to do the movie. And
one question is, Wayfair is Justin Baldoni's production company? Okay.
Yes.
All right.
And there has been, it's him and his co-producer, who's also obviously listed in a lot of these suits, Jamie Heath. And then they're backed by, and Chris, I don't know if you can fact check this in the moment, but they're a billionaire named something or other. And so this I will put in, they're all members of the Baha'i faith, and that kind of comes into play because there was and is kind of coming to light now in some of these allegations, like an uncomfortable use of religion on set.
Justin Baldoni is? Okay.
Yes, all three of them.
All right.
And so there was a Hollywood Reporter article that just came out recently that was talking about kind of the very comfortable, like, they're very they lead with a lot of that energy, and so that they'll be on calls with like agents and stuff and ask them to all like share something they've never shared with someone, like do stuff that like they do in their personal lives, but they're bringing that into a work setting. And so the billionaire that backs them, I know, is also of the Baha'i faith, which granted I don't know very much about.
For his production company?
Yeah. So
you are right about that.
Yeah, no, that one I know I was right about, but I just don't know the name of the backer. So anyway, all of that being said, so they did this film together. They shot, I believe, in 2023. Steve Sarowitz, okay. And so all of this started, the lawsuit itself started most recently in 2024, but they shot in 2023, and they did shut down due to the strikes and also a COVID scare. But there was this sort of break in filming in which Lively and her team was like, I will not return to shooting unless these allegations are met. So we have stuff that covers like during shooting, and that's a lot of the evidence that's going to be used during this like hostile work environment suit. But then after the movie ends, there was this very big public backlash against Blake Lively during the press tour. People were, upset that she was, promoting a hair care line, and that she was, maybe didn't come off super friendly in interviews. And there was a lot of like personal attack against her. Then we get this big article from the New York Times that comes out demonstrating that this, or alleging that this was a planned attack from Baldoni's team and a PR crisis firm that he had hired, that included text messages that were subpoenaed, but that doesn't really make sense because it was a complaint, not a lawsuit yet. So most likely they were given these text messages in collaboration with the original PR firm they were working with, that just outlined that Baldoni and his team had purposefully maligned Blake Lively's image in order, for what purpose, I guess, maybe in retaliation to like her having a cut of the movie and other like producerial like fights that happened on set, or also potentially to stave off the workplace harassment that eventually came to light anyway. So a lot of nuances. At the end of the day, this movie made $351 million.
Yeah, it did well from what I read.
It did very well.
Yeah.
So there's also a lot of, opinions that maybe that this was purposeful in order to like get butts in seats.
Yeah.
I think that's clearly no longer the case. However, it did make a lot of money. So there's a lot of allegations here.
Yeah.
There's a lot of lawsuits. There's Lively's original suit. There's Baldoni has a suit against the New York Times for that article. He also has a suit against Blake Lively. And I believe now there's another suit against Blake Lively by a publicist. There's a lot of lawsuits. Everyone's filing.
And then from what I read, at least I think 2 of those lawsuits have been consolidated. So I think, because who filed first? Blake?
Yeah.
Blake filed first, and then I think Justin...
It was a very quick
countersued, right? I think those.
Well, he sued the Times first.
He sued the Times first, but then ultimately sued her as well, right? So I
Yeah.
think his lawsuit against her has been consolidated with her lawsuit against him in this the New York litigation that's potentially going to trial in whenever it is, like May of 2026.
Right. So a lot of this, I guess, going back to kind of our caveats, I find personally interesting, I think because of this, I do think there is a level of like a misogynistic narrative around how Blake Lively's been framed in the press, that I think is a piece of the puzzle here and kind of how they're waging these press wars against each other. Ultimately, we're not really talking about press wars. We want to kind of get into like, what is this lawsuit? What can we learn from this lawsuit? I think, coming from an employment background, it is, next to PI, probably one of the more relatable practices that people experience in their everyday life. Like if you're not at home, you're probably at work. So I think, what can we take away for, your average person who may or may not be experiencing their own iteration of this? So let's kind of dig into the timeline. So I want to get your thoughts on the original workplace allegations that she and her team set out in 2023 against Baldoni. It was a list of 30.
Yeah.
30
There were a lot
complaints.
of allegations.
And I want to go through them because I think the thing that's odd about a lot of these is obviously a lot of them are relatively like sexual in nature,
Mm-hmm.
because the film was dealing with, a lot of intimate scenes. They had an intimacy coordinator,
Mm-hmm.
though in her complaints it lists that they need to have one, even though they did contractually have one at the time.
Mm-hmm.
So I guess from your experience in employment law, like what is this list, and is that normal for like how this came to be in the middle of filming? I mean, maybe I don't know if on set is any different from like a normal workplace, but like should somebody experience 30 very specific incidents with their employer, like is this the way that normally goes about, like submitting this list of complaints and asking that to stop?
I have a couple of thoughts. First, just to backtrack a little bit, because I know you said we're not as concerned with the publicist games, right, or the PR games, but I think a lot of how the public is going to consume this and the lens they see it through is going to be framed by these PR games that are going on the back end. And much of the public doesn't even realize this stuff is going on the back end. So for me, just because, I've been in LA for a long time, I've come across people from all walks of life. And with respect to the entertainment industry and how some of these things that just like magically pop up on your TV or in your quote unquote newspaper come to fruition, there's people that are behind, there people who are behind that on both sides. And so I think it's important in the sense that you also mentioned like the court of public opinion, because the way these stories are coming out and being framed on either party's behalf, even if you take Justin Baldoni and Blake Lively out of this, if there's a celebrity and a story with 2 celebrities involved, right, there's going to be people on either side of that story working for either celebrity who are crafting things on the back end to put specific narratives out there they want the public to believe. So I think even in this case is probably a great example of that, because there's been so much activity on each side. It hasn't just been like, Blake came out and said one thing. It was like unrefuted by Justin. And he was just basically like, oh, we'll let the legal process play out. Like, no, like he did things on his behalf. Right. And so there's been specific action taken on both sides. There's been stories and narratives that have been crafted on both sides that are, it's Olivia Pope in the background who's quote unquote spinning these things for either party. And so for me, what I always try to be cognizant of when celebrity stories come out is that this is a framed narrative that somebody behind the scenes you don't know about is crafting in such a way because they want you to believe something. For me, like, I think at the end of the day, we'll probably never really know what happened, just because that's also part of the strategy, is to put so much stuff out there that it kind of muddies the water. And then you're never really going to know what happened other than, Blake and Justin, maybe a couple of these other people who were involved, like Jamie Heath or whatever the guy's name is, or the people who were alleged to be involved, even Ryan Reynolds, because Ryan Reynolds
shows up,
came to some of these meetings, right?
Yeah.
At Blake's request, I think. And so there's a handful of people who know what really happened. And then there's spin teams on either side that are like, they're in crisis management mode and they're trying to craft a narrative in order to win the court of public opinion. So for me, that's kind of where I start. And then when we get into the nuances of what is alleged to be happened, like I try to, look at it through that frame as well, just so I can maintain more of an impartial and unbiased, perspective. With respect to like these allegations, that this list of things that, Blake alleges happened on set, I think some of this and the way it got brought up is probably specific to the entertainment industry and a movie set, because, I don't know SAG-AFTRA laws or bylaws or anything like that. Like, if something like this happens, is there a process where it's supposed to be brought to light, through the union, for example? Like, this might be exactly how this was supposed to happen via SAG-AFTRA, union laws or something.
Well, I think
like
what we learned from the Me Too movement and, the rise of intimacy coordinating, which is incredibly new and still like doesn't even have a union of its own. It hasn't joined the Teamsters or any of the other unions. Like, I think what we have learned is that there isn't really a process.
Okay. That's not good.
Like there are, like, you can report it to the union and they can try to, the union does have lawyers, like they do have ways of operating. But I think the biggest thing that we've seen is like when things happen outside of the studio system, like, I mean, this was made with Sony, but at the same time, it was his production company that was running the show. And so something that I find interesting is that there really isn't, like, he was her director, he was her co-star in a role that you're playing someone's abuser, and he was her producer, right? So in 3 different power positions, and now, on the flip side, she has a much larger celebrity name. She's coming from, old Hollywood. Like, so there is that element to it. But like, should someone even like be uncomfortable in a, maybe even with an intimacy coordinator there, something that I don't know how you would pick apart as an employment lawyer is like, where do you turn? It's not the same as a traditional workplace. Like, you don't really have HR in that same way. It's a small production company. It's really just him and Jamie Heath and maybe some assistants. Like, where do you go? And I think taking that to, even in a normal setting, like, what do people do when they feel uncomfortable in a workplace setting? Like, what should happen?
I mean, I think you hit the nail on the head with HR or some sort of HR equivalent, because like in a normal workplace, there should be somebody who, if something like this were to arise, the employees feel comfortable going to that person to raise these concerns and not thinking that this person is also like in the pocket of the boss, right? Because I think the other thing you said that's very salient is this guy had like 3 different kind of power dynamics rolled into one. So therefore, when something like this does arise, who is she supposed to turn to, And so hindsight is 2020, right? But what I would say is, in a situation like this where these things going in, like, this guy's going to be the director, producer, co-star in a movie about, I haven't seen it, but like violent domestic violence, right? Like, if something arises where I have a concern about how I'm being handled,
Yeah.
who would I be able to go to? Like, ideally, in a perfect world, right, you would have mapped that out beforehand because, oftentimes people don't even think about that. Like, her brain might not have even gone in that direction of like, oh, yeah, I'm not going to assume like this guy's going to be a bad actor. So she's not even thinking about that, but that's why I say hindsight is 20/20. And like in a perfect world, from a logistical perspective, you would have that mapped out in advance, because then I think that might have also been a check on him, right? If he knew that, okay, if something arises, she's going to have this outlet where she can go and raise these concerns to this person, that might be a check on him in the back of his mind, because he's like, I can't just be a, malicious, reckless actor, because I know that she can take this to this person and then it can get escalated and blow up, et cetera. And
which
so,
it did.
Yeah, exactly. So like in a normal workplace situation, right, again, there should be like, ideally an impartial HR type person specifically for these types of concerns that the employee can go to and say, hey, I'm having this concern about, this employee or this manager or this supervisor or whatever.
Something else I find interesting and complex about this as a workspace is that actors at the end of the day are hired hands.
Yeah.
They're like, for all intents and purposes, 1099 contract workers.
Independent contractors.
So like, you getting your next job, which is something that maybe a W-2 employee in the same situation would be like, okay, maybe I want to leave this company and go work at XYZ company instead. That's not necessarily always possible. And maybe even thinking about some of the smaller, because I know in Blake Lively's suit, she brings up like, I am doing this on behalf of other co-stars on the set that also felt uncomfortable, right? So like somebody without her name or her stature, right, might be worried about getting their next job, which is more, I think, aligned with a contract worker. Like what would happen, I guess, like if we could take this to another industry, for example, like if, I'm trying to think of like what a contract role might be that somebody could experience, discomfort from somebody that's hiring their, whether it's, I guess, like an agency or, I don't know. Did you ever come across contract employees experiencing harassment?
Independent contractor employees, not that I can remember, but I think in an industry that's probably somewhat akin to this would be like the modeling industry, right? Because aren't those models independent contractors?
I would assume so, right? Because they'd be hired by probably like, the same thing, like they would have an agent that would send them out, and then Sephora or whatever would hire them, and their agent would get a cut.
But like historically, like if you watch those documentaries, like I think there was the Apple documentary that was like the 4-part series about like, it was like Naomi, I think Cindy Crawford.
Yep. It was like the 4 biggest models of the 90s.
Christy Turlington, right? I think, and one other person.
Oh, Linda Evangelista.
Yeah, Linda Evangelista, right? And like they all had stories about that, right? Especially like they were young when they first started, and some of them, like Linda, I think had a real, or it wasn't Linda, it was one of the other ones, maybe Cindy, but she was like, she went to Japan, I think, when she was like 17 years old and had, a really negative experience. And so I think that industry is probably somewhat akin to this, because it's like for them, they're thinking, who can I even turn to, right? Because their agent who send them out on the job a lot of times is just going to be like, oh, they just chalk it up to like, well, that's the industry. And if you want to get booked, you have to keep doing it, right? So then like you're in between a rock and a hard place, because you also don't want to be known as the model that's like unduly difficult or like hard to work with just because you rebuffed in advance or rejected in advance, right? And so I think those situations are tough just because the industry is not set up in a way to protect you or to handle a situation after the fact when something like this happens.
And I think that's what and I think modeling is a really good example, right? Because, that model is both the product, but also like a human being. And I think it's difficult to not dehumanize it, like even, looking back at labor codes and like when we would have children in the factories or in the mines, right? Like, I think we have been able to learn from those mistakes, but I think these industries that are glorified in very odd ways, like the entertainment industry, like the modeling industry, right? Like, if you're photographing like a lip gloss, like you can do whatever you need to do to that lip gloss to make that shoot great, but like at the end of the day, you're working with a human being, whether that is on a film set or a modeling set. So I think with that in mind, especially when you're tackling, in this case, source material that isn't just intimate in nature, it's violent in nature. How, what a big conflict of interest on his part. And I understand that's more like the nature of independent film. And, wanting to make that story, sometimes you have to wear multiple hats. Sometimes you have to write, direct, produce, and do that all. But when you're dealing with material that's so sensitive, I don't think a lot of people, because maybe they haven't had 9-to-5 jobs, they haven't worked in a corporate setting where they realize, the importance of a corporate structure sometimes is that there are separations of church and state, that people can, have that safety net. Wouldn't think, well, if something went wrong, So I guess going back to the complaint list.
Well, I think also just to interject real quick, I think it shows the importance of the corporate structure, but also the importance of unions in industries that, it might not be a W-2 employee situation, because in those situations, you could be an independent contractor, but if there's a union that exists to help you collectively bargain, to protect your rights as whatever type of independent contractor you are, that's what's important to also help you get, relief in these types of situations. And like a lot of these industries where you see these types of situations running rampant, like the modeling industry, for example, or like I know in film and, in entertainment, there are unions that exist, but I don't know to what extent the union would be involved in a situation like this. Like, just because for any movie that gets shot, like, is there union relief that if somebody feels aggrieved on the set, is there a union they can turn to? Like, I don't know. But I think that this situation, again, writ large, just speaks to the importance of unions in situations where an independent contractor might not have a traditional path where they can go seek relief, like an HR in a W-2 employee, situation or corporate situation. So I think that historically, that's why unions have been so important in America, is to protect the rights of independent contractors or any other type of worker who isn't necessarily going to have some other type of corporate structure that they can go to and seek relief.
Yeah. That's interesting. And I think, obviously SAG-AFTRA is involved in collective bargaining with the studios. And they do fine productions when they do misstep. And when you break, there's always that old saying, like, the reason you have a chair on set as an actor is because of SAG. Like, they're the ones that collectively bargain to make sure you get your breaks and all of those same things. And I think this, in a lot of industries, still remains that big question of how do we protect people, especially in a workplace where this is going to come up more, because you're dealing more often with material. Like, you're not going to be in a situation where you're kissing your coworker in a lot of industries, but this one you are. So why is that not something that they're consistently reforming and making that a space to be that intermediary HR? And I'm sure there's a lot of conflict of interests within the film industry in itself. So I guess let's kind of go through some of these. Were there any to you from your background that stuck out as complaints?
On this list of allegations?
Yeah, and we'll list these on the screen so people can read them. But obviously there's 30, so we won't get through all of them. And I can pick out the ones that kind of stuck out to me.
I think any of the ones that don't really have anything to do with the filming probably jump out, because it's like, why are you doing that? It's like completely extraneous and unnecessary. So, for example, there's allegations like these guys were just, I guess, showing nude videos or images of women for no reason, basically, right? Like the first allegation,
right?
No more showing nude videos or images of women, including producer's wife, to Blake Lively and or her employees. Like, that has nothing to do with the film, and I'm sure like Justin C might come back and say, "Oh, we did it for this purpose."
And they have the rebuttal to that.
So
was that it was in the context of I think the nude videos was in context to the birth scene in which the Jamie Heath was. They were discussed. they were talking about birth and like how one of their wives like ripped off her gown while giving birth, and it was a lot of like, let me insert my personal content, which, you know, again, to take out the, you know, the gossip angle of it, because again, I'm not as interested in that, but I think with artists, and I say this as coming from like, I'm a member of SAG-AFTRA, like I you know, started in the entertainment industry, so my interest here lies primarily with like, how do you separate church and state here? Like, a lot of artists work from a place of this was my personal experience, and this is what I want to show up on screen, especially as the director, right? You're like, well, I really want this birth scene to look like blank because this was my experience with my wife. Great. How do you have that conversation in a way that's not going to make someone else uncomfortable? And I think you have to be able to talk about that as a like ephemeral thing before you can talk about the literal thing, if that makes sense. Like, you have to say, if I want to talk about personal matters in order to convey what I'm feeling about this artistic vision that I have, right? Like, what's the best way to do that? And to have that kind of like mediator, in this case, an intimacy coordinator, like, how do you have that discussion? And I am not an intimacy coordinator, so I'm positive that there is an art within doing that, since they are also collaborators in that.
It feels like a lot of this stuff just wasn't talked about in depth before the shooting started. Yeah. And then that led to this situation arising where you have all these situations occurring that are making someone uncomfortable because, you know, I would imagine you as the director, producer, co-star, it would be more incumbent upon you, because you said his production company bought the rights to the book. Yep. So like they know what the book is about. They have an idea of what the film is going to look like. They know what the content of the book and the film are going to be. So if he's the director, producer, and the co-star, he has all this creative vision in his head, then I would think, and of course, again, hindsight's 20/20, but it's like, we should talk about all of these things beforehand, because this film is going to get really gritty. It's going to get really real. This is the vision that I have for it. This is how I'm going to play the character. And it just feels like none of that was really fleshed out or discussed beforehand. It's just basically like, we're going to start shooting and just, you know, whatever happens, happens.
Right. Right. Which was interesting. So point 11 is that an intimacy coordinator must be present at all times when Blake Lively is on set in scenes with Mr. Baldoni, which there's a couple layers of that makes it interesting, right? Like, at all times when she's on set in scenes with him, I mean, not every scene that they had together was an intimate scene. So asking for a third party to always be there, I mean, that kind of goes back to my first point about like, what do you do when your co-star is your director, which is your executive producer, like, just that ball of conflict of interest, and now you don't feel safe with that person. You know, I don't know how you unstitch that conundrum, but yeah, I guess the other one I wanted to bring up was the COVID one. So SAG does have some pretty strict COVID rules, and they didn't follow them. So I actually haven't heard of if they've been getting fined, because that is what the union is supposed to do, is like fine the production, so that, you know, it's like a slap on the wrist, like, don't do that. But if that's the case, like, I don't know. There's some in here that I guess haven't been covered in the ways that if this really is just a hostile work employment suit, there are repercussions that I would think that would extend beyond just Blake Lively, and in this, like, her versus him defamation suit now. COVID being one of them, since, like, you know, if there's documented evidence that she was exposed to COVID and got COVID with her infant son on set, like, and they potentially didn't follow the SAG-AFTRA COVID rules, like, would there not be repercussions for that? So there was just
getting fined by SAG-AFTRA.
Yeah,
that's interesting.
Yeah, and I don't know if beyond SAG-AFTRA, if there's like other, you know, workplace or employment law, like, there's so many pieces of this. I guess, like, as an employment lawyer, like, how do you even begin to, like, go after different pieces of this? Because obviously there's, like, the pain and suffering, there's the sexual harassment, but, like, that's also like she's documented evidence that she got sick on set because of their negligence.
Physically sick?
Yeah, I mean, she and her baby got COVID.
Oh, they did get COVID.
Yeah, they did.
I see it says that they were exposed to COVID, but they actually contracted COVID.
They
And
did.
so it's confirmed like she caught it on set, her and
Yep.
her baby?
Yep.
Okay.
And they weren't told about it.
That somebody was on set
That had
with
it. So they weren't told that they were exposed to it.
Okay. For me, in terms of the lawsuit, with any lawsuit, you got to start with basically the jury instructions, because the jury instructions are going to encapsulate what the cause of action is and how you have to go about proving it.
What is the jury instruction?
The jury instruction is, so when you go to trial, there's a list of jury instructions in various categories that the judge reads to the jury at particular times to help them with their deliberations. So there's like a preliminary set of instructions that's just like, hey, welcome to the trial. This is what trial is. This is what trial is going to be about. This is what your purpose is as a juror, blah, blah, blah. There's an evidence section that says you're going to hear evidence from witnesses. You can only consider the actual evidence in the form of testimony that you hear from witnesses, or in terms of documents that get admitted into evidence. Anything other than that is not evidence. You can't consider insurance information. In the state of California, there's a jury instruction specifically on insurance that says you can't consider insurance. Reason being that you only have to consider what the damage, like if the plaintiff proves their case, then you only have to consider what the damages are and the damages that the plaintiff has proved, and then value those damages. Because if you knew that the other side only had X amount of insurance, or that they had a lot of insurance, that might influence the number that you give to the plaintiff, right? Like if you knew the defendant had $1 billion worth of insurance and you thought the case was worth $1 billion, you might give $1 billion because you know they have the money to pay it. So you're not allowed to consider insurance in the state of California. There's other specific jury instructions that have to do with negligence, damages, etc. So the judge will read those jury instructions to the jury at particular times in the case to help them with the deliberation process. So in any case, like in our cases, there's a negligence jury instruction that says, this is what negligence is. Basically, this is how the plaintiff, like these are the elements of this cause of action of negligence the plaintiff has to prove. So in her case, you know, in New York, I'm sure New York is somewhat similar. Like when she filed her complaint, there's different causes of action in the complaint. And then there's going to be jury instructions generally that correspond to those causes of action that say, these are the elements of this cause of action. Like these are the elements of hostile work environment in the state of New York. And the jury instruction says, that's how you have to prove it. Right. And so whatever her allegations are in her complaint, like that's where I would start in terms of breaking down in a court of law how these allegations that she's making translate to actually proving a hostile work environment in the state of, and like one of the basic elements might be that, you know, what she's alleging had to occur within the workplace. So in a case like this, like workplace, the umbrella has to be broad enough to encompass work on a film set, you know? And so like in the state of California, I'm not sure with respect to like the interplay between workplace harassment and something that happens on a film set, like, right. Does that constitute a workplace for purposes of California law? You know, it might be that, because similar to workers' compensation in the state of California, workers' compensation gets handled through the Workers' Compensation Appeals Board, like under SAG-AFTRA. I don't know if there's like,
there is
supposed to be revolved
for actors too, yeah.
But for like hostile work environment, is hostile work environment supposed to be resolved under SAG-AFTRA? Like, do they have some sort of SAG-AFTRA like remediation process that she's supposed to go to and bring this to SAG-AFTRA? Or
we'll fact check
can she file a civil suit and allege all these things and, you know, potentially get money for a hostile work environment claim based on things that happen in a film set?
It seems like that from the way that this has been moving forward, at least.
So assuming that she can, then I would look at, you know, if we could probably bring up a copy of her lawsuit, but what are the causes of action she's alleging in her lawsuit? And then finding out what the elements are to prove each of those causes of action. And then it's going to be incumbent upon her, if the case were to go to trial, you know, her attorney's going to have to stand up and say, you know, this is what constitutes hostile work environment. It has elements A, B, C, D. And we know in this case, Justin Baldoni and Wayfair and Jamie Heath did A, B, C, D.
Right. And how does that work in tandem then with his defamation suit?
So
if they're trying them both at the same time.
From what I understand, she filed a suit against him, right, for hostile work environment. did he countersue her for defamation, or did he sue the New York Times for defamation, or both?
I believe both.
Because whatever suit that he filed against her is, I think, the one that got consolidated with her lawsuit. And then he has a separate lawsuit against the New York Times for defamation.
Yes. Yeah, for the story that they ran with her.
Yeah.
So he accused them of extortion, defamation, invasion of privacy, alleging that they attempted to hijack his film's production and falsely accused him to damage his career.
That's the New York Times lawsuit.
That's Ryan Reynolds and Lively.
Oh, that's the Ryan Reynolds law.
Yeah, so that's the $400 million lawsuit against them.
That's the one that Baldoni filed against them for $400 million. What are the causes of action again, or what's he alleging?
Let's look up his. So I might actually have it in here. Allegations. So yeah, he sued the Times for defamation, and then he countersued Lively for defamation and emotional distress.
Okay.
So the key allegations were Baldoni alleged Lively's lawsuit and public accusations were part of a calculated campaign to defame him and force him out of Wayfarer Studios. He claimed intentional infliction of emotional distress through false allegations and reputational harm. And he asserted that Lively's legal actions breached confidentiality agreements.
So then, I mean, there's multiple layers for that too. But if we start with the confidentiality agreement, like if Baldoni is alleging that Blake violated a confidentiality agreement,
right,
there might be what's known as a liquidated damages provision with that agreement that basically says, if you violate this agreement, you have to pay these damages as a result of violating this agreement. So whatever that number is, it might be a large number depending on the severity of the grievance, right? Like the severity of the breach of the confidentiality agreement, which is, essentially it's like an NDA, like a non-disclosure agreement. So,
but would that all be tried at the same time?
Well, it seems like the court consolidated her lawsuit with his lawsuit. So both of their lawsuits are going to get heard at the same time because they got consolidated.
And just thinking about like what those, like when they're, putting together their legal teams, like would you not, because there's so many different specialties within both of those, like you have employment law, you have entertainment law, you have like, there's, I guess, how do you put together your little Avengers team of like?
Well, I mean, if you were to use the O.J. Simpson Dream Team as an example, you had Johnny, who was the main trial attorney. You had this guy, F. Lee Bailey, who was a historic trial attorney. Like he represented this woman Patty Hearst. And like the Symbionese Liberation Army or whatever that was, like he represented her. But that guy was like a famed trial attorney, right? So they brought him on specifically to handle Mark Furman.
Trial attorneys, because obviously you guys are a trial law firm. So trial attorney doesn't always just tell you what their practice is. It is like, I go to court, I practice in trial.
Well, I mean, I think F. Lee Bailey, Johnny and F. Lee Bailey, they were criminal defense attorneys, right? Okay. Johnny also practiced civil, but F. Lee Bailey was a criminal defense attorney because that Patty Hearst case, I think, was a criminal case. He defended her, and so he was a famed trial attorney, criminal defense attorney. He specifically handled Mark Furman, who was the main police officer like involved in that case that, he got accused of various things in terms of like being racist, planting evidence, et cetera. So F. Lee Bailey handled his cross-examination. You had these guys they called the DNA twins. So one guy's name was Barry Scheck. The other guy, I think his last name was Newfield, something like that. But they specifically, so on the police side of things, there was a criminalist or criminologist or something like that. This guy named Dennis Fung, who, when the crime scene was being investigated, like he was responsible for the collection and handling of all the blood evidence. And so this guy, Barry Scheck, who was on OJ's defense team, he was the DNA expert on their team. So he handled Dennis Fung. And then there were other people who handled other like parts of the trial, but everybody kind of had their niche, right? And Johnny was like the quarterback who was basically coordinating all of them. So I think for something like this,
Because this is all
Justin Dale.
civil. This is
This
not
is all
criminal.
civil,
Right.
but there might be, because you brought up different things like entertainment
Right.
law or like this area of law or that area of law. So it's like when you're assembling your Avengers team,
Right.
you got to find somebody who's proficient in whatever area of law you need that person for to be a part of your team. So, you know, he might need some sort of entertainment law expert. He might need some like a defamation attorney, because an entertainment lawyer who understands entertainment law might not necessarily be well versed in defamation specifically. So he might have somebody who's, you know, specializes in that to handle that aspect of it, because defamation, especially when you're a public figure, it's a much higher bar to prove defamation
Right.
because you've, you know, the argument is you willingly put yourself in the public eye. So therefore you have less of an expectation of privacy
Right.
when it comes to defamation, which is just libel and slander, right? Libel is written, slander is
Or
spoken.
what they're trying to, or I guess what he would be trying to prove, right, would then be like, I am losing potential work, or
So
there was
that's the other
financial
thing.
loss, or I mean, obviously emotional distress is
Yeah.
one of his major allegations. But I guess is that the other way you prove defamation?
So, I mean, defamation is basically, generally the elements are, it's a statement that gets published to a third party and then you suffer some sort of like reputational harm, right? So it has to be quote unquote published. Like if you and I are just having a private conversation about somebody and we disparage that person in our private conversation,
Yeah.
but it doesn't go beyond you and I, there's no defamation because it hasn't been published. But if you and I on this podcast were to say something disparaging about somebody
Right.
and put it out there, now it's been published because it's gone out to the world, right?
Right.
And so with him, this was an article that was published
Right.
literally published in the New York Times. So there's
Yeah.
statements that have been published, and now he's alleging he suffered reputational harm or whatever, right? But that was the other thing that I was going to say about this number, 400 million, when you brought it up earlier, is that number could be comprised in large part by business he's alleging that he lost out on
Right.
as a result of this. Like he might have been saying, oh, I had this, you know, whatever, like this $100 million, you know, endorsement deal on the
Yeah.
table, this other movie deal, this podcast deal or whatever. All these things fell through. And as a result, I lost, you know, whatever, $350 million worth of business. And then there's $50 million I'm alleging in pain and suffering and emotional distress as a result of losing all that money, as a result of, you know, being pilloried in the press and being made out to be, you know, this abusive, you know, sexual deviant or whatever, you know? So
this is something you do deal with on a daily basis. Like, how do you prove emotional distress? Because that's a very intangible, like.
So in terms of, you know, getting back to jury instructions, like in the state of California, there's a specific damages jury instruction. So in California, we have the California Civil Instructions, CACI. We refer to them, you know, by shorthand. And I believe it's 3905A is the jury instruction that pertains to pain and suffering. So what that jury instruction says is essentially that pain and suffering is comprised of the fact that you had to endure physical pain, because we're personal injury attorneys, right? Physical pain, mental suffering, anxiety, loss of enjoyment of life, humiliation. So like those things, like loss of enjoyment of life, anxiety, humiliation, and any other measure of damages that you can think of that's appropriate. But for him specifically, mental suffering, anxiety, loss of enjoyment of life, humiliation, those are things he's probably alleging that he went through as a result of this. So in order to prove it, ultimately, he would get on the stand and testify as to how this has affected him. Because with our cases, it's the same. If we go to trial, ultimately the plaintiff has to get on the stand and tell his or her story about how this, you know, physical injury has affected. Oh, like I used to run every day. Now I can't run as much anymore because of this injury. I used to garden every single day, but now I can't bend over to tend to my plants. I can't bend over to, you know, water the plants with the hose. I can't pick up, you know, my infant child anymore because my back is in too much pain. I can't go to the gym and exercise the way I used to. Like my quality of life has been affected. I'm in pain every single day. You know, on average, it's a 3, but on a tough day, you know, if I'm working all day, because I still have to work to feed my family, it might be at an 8 at the end of the day. So it's from the testimony of the person who's putting forth that claim. So he would have to substantiate that. As far as the emotional distress, as far as like, if he's saying I lost a whole bunch of jobs, like for me, like if I was on the other side of that, if I was Blake's attorney, I'd be like, show me the proof. Like I want to see a deal memo.
Offers,
I want to see a memorandum of understanding, a letter of intent, or something to substantiate that you like already had this deal and lost it, or it was at the finish line and you lost it.
Right.
But also like going back to defamation, in the state of California, I'm sure it's probably true in New York, truth is the ultimate defense. So if I'm alleging somebody defamed me, but they can prove what they said is true, truth is the ultimate defense. So, it's not just that I'm alleging you said this about me and I suffered reputational harm. If the person who said it can prove what they said is true, then there is no defamation.
Okay. I guess I kind of feel good about where we're at too. What's your take on like, this starts, obviously it starts as like as a press war thing over the summer, but it becomes a workplace harassment suit that turns into two defamation suits. I guess what do you make of that, like as a defense on his end? Like I know you're saying like what he kind of has to go in, what his team should be probably doing to prepare for his offense and his defense, I guess. But like, they signed that list of complaints. Like their company signed that stating like, yes, good, back to set we go. So I guess like, how do you then walk that back and say that that's defamation? If like, you could say it's a breach of contract, sure. But like if your company, whether or not you believed it was true when you were signing it, you did sign it. So legally binding them to these statements that she put forth.
I would have to see exactly what they signed. Like, because there's a difference between signing that, like, if it's just a list of allegations and then they sign it and they say, yeah, we agree none of this stuff will happen, moving forward. That's not necessarily a concession that they agree that it happened in the past, right? They're just saying, like, if you send me a list of 10 grievances and you're like, I don't want this to continue moving forward, or I don't want this to happen moving forward, I could sign it and say, yeah, I agree this won't happen moving forward, but I'm not conceding that it happened in the past. So I don't know if they just looked at the list and like, I don't know what specifically they signed. Like, I don't know if they signed something conceding that it happened in the past and making sure it won't happen in the future, or if they just said, we read your list of grievances, we agree that this should not occur on set moving forward, and we sign our agreement that this should not occur on set moving forward. As far as your, initial question about kind of what do I think about her filing suit, him filing a countersuit, this is Hollywood. It's entertainment. There's a lot of aggressive type A attorneys out there who believe that the best defense is a good offense. And so their strategy, his team strategy might have been, okay, we're not just going to sit back and take this lawsuit and defend against her lawsuit on the merits. We're going to file our own lawsuit and put her on the defensive. So she's going to understand we're not just going to, quote unquote, take this lying down. We're going to go on the attack as well, not just against her, but also the New York Times, because we think her team colluded with the New York Times to put out this narrative to besmirch my reputation and, mess up all these deals that I have in the pipeline and, maybe get me blackballed from the entertainment industry altogether. Because, if he thinks that's a possibility, that she's going to put this narrative out there and then he'll never work again, like, you'll never work in this town again.
Right.
That whole saying, like, that might comprise some of these damages as well. Like, you're trying to basically kill my career in the industry. He looks like a young guy, I guess. Yeah. Like, I don't know how old he is, but like, you're trying to effectively end my career in Hollywood and the entertainment industry forever with these allegations. I don't believe they're true. I think they're unfounded. I have my own legal team. So I'm going to file a countersuit and put you on the defensive. We're going to consolidate them. So combine them together. And then if we go to trial, everything's going to come out to the jury and we're just going to put it in the jury's hands and let the chips fall where they may.
Why do you think they both want to go to trial?
I don't think they both want to go to trial. I think it's very rare that people actually want to go to trial because when you go to trial, trial's a roll of the dice. especially in criminal law, right? Like a lot of times in criminal law, your freedom is at stake, like your actual freedom, right? And so if you think about the criminal justice system, that's why the criminal justice system is predicated on prosecutors and district attorneys overcharging people, typically people of color, because they want to threaten them with all this time and then say, we'll offer you this plea deal. A$AP Rocky, perfect example. The A$AP Rocky trial, he was facing 24 years. They said, I think they offered him 6 months, right? Because they said, you're facing 24 years. If we prove all these, like if you roll the dice, go to trial and you get the maximum sentence imposed, you're going to go away for 24 years, you know? I guess there was some dispute as to whether he's actually married to Rihanna, right? But like your partner's Rihanna, you have young kids with her, you're going to miss potentially 24 years of their life because like you're not going to get out till you're like, I think he's 36. So like if you do all that time, you're not going to get out till you're 60, right? But do these 6 months. We'll give you a 6-month plea bargain. I don't know what the exact terms were, but it was like a 6-month jail time plea bargain. And then you'll be out, you know, you can go back to Rihanna, whatever. But like he stood his ground, right? And ultimately he prevailed, which I'm sure everybody's seen the video where he dove into Rihanna's arms, right? But like the criminal justice system is predicated on overcharging people so you can use the prospect of that time they're facing to plead them down and get a consent. Because there's a lot of people that'll plead guilty even though they're not guilty because they're facing, you know, a whole bunch of years. And so like a small plea bargain in a system that most of the time we don't have faith in anyway, you know, people, and like a lot of these people have public defenders, right? So they're like, they might not even have faith in their public defenders. So they're like, I'm just going to take this time, even though I didn't do it because I'm facing 25 years, right? And so the civil justice system is the same way in terms of it being a roll of the dice. Because even when A$AP went to trial, that was still a roll of the dice. That's why, like, you know, when you're standing up and that bailiff is reading that verdict, you don't know what's going to come out of his mouth. I'm sure he was super nervous, you know? And so similarly, in a civil litigation, you don't know what the outcome is going to be. In civil litigation, it's money that's at stake, not your personal freedom. But you don't know what the outcome is going to be. So going to trial in a civil case is also a roll of the dice, especially because oftentimes you're going to try to settle the case or resolve the case short of trial, right? If you strongly believe in your case, you might look at the other side and say,
they both said that, right? Both of their legal teams. And I don't know how
say that
they
publicly
do.
Because they're playing media games, right? They want to, you know, it's the same thing where like anytime any celebrity gets accused of anything, their criminal defense attorney, like if it's a criminal case, right? Their defense attorney calls a press conference, gets in front of the media and says, my client looks forward to having his day in court and being vindicated. The truth will come out. They all have the same, like, you know, they read from the same script, right? And so this is very nascent. Like this is new. Like these complaints were filed relatively recently. So of course, in the beginning, the attorneys are going to come out and be like, my client looks forward to his day in court so he can be fully vindicated. She looks forward to be having her day in court. So you guys will get all the facts, right? Like they have to maintain that public hard line because they know the other side is going to see that. So the other side is going to be, wow, these guys are really serious. Or they'll just be like, this guy's just puffing. This is all hot air, you know? But for the public, this is also more so for the public in terms of getting the narrative out to the public and like the forward facing, you know, front that you want to have for the public in terms of, you know, my client believes strongly in his case. My client did nothing wrong. My client's going to get vindicated. So the public's like, oh, wow, maybe he didn't do it. Maybe she didn't do it or whatever, you know? So at the end of the day, I think a lot of that is just puffery for the media, but behind closed doors, because, you know, we also I didn't watch the Johnny Depp trial, right?
I did.
But like everybody watched that. And so there's a lot of dirty laundry that got aired, right? And so neither side might not want to have their dirty laundry actually get aired in a public trial. So I don't, you know, just being in my industry in particular, but also just living in LA for so long and seeing kind of the entertainment industry from the inside out in some ways, like I just feel like I know when, you know, media games are being played. I know just from an attorney perspective and dealing with attorneys, I know how attorneys operate, especially when it comes to press conferences and the media and stuff like that. So I think a lot of this is just fodder for the media, but behind closed doors, there might come a point on the eve of trial, where both sides are like, let's see if we can resolve this with a confidential settlement. So both sides can avoid having to go to trial and get their dirty laundry aired, because regardless of, like, let's say that, like,
well, because her team was also trying to put a gag order on, because he made that.
I saw that too.
Just to quickly speed ahead in the timeline, he's, Justin Baldoni has since made a timeline of his own on the website with evidence to lay out the full story from his opinion. But they failed. The judge did not grant them the gag order to stop that. So I guess, does that sort of indicate, like, they also probably don't want certain things getting out there? They probably also, like, does that point towards a settlement? Yeah.
I think that's probably more so her team might have just thought, we're going to file this lawsuit and then we're going to have the upper hand because we're controlling the narrative. And then when he files a countersuit, but also puts up his own timeline, now they've kind of, his team, Justin Baldoni's team, has kind of usurped that advantage because they went on the offensive, right? Like, Blake's team might have thought, we're going to be on the offensive because we're filing this lawsuit and he's going to have to deal with it. They might not have ever considered, the possibility that he would file a countersuit, put together this timeline, and, like I said, kind of usurp some of their leverage. And so now that he did that, they're like, oh no, we want a gag order, but that, in some ways, a gag order can be a good thing, because you also have to consider, if the case actually does go to trial, all of this stuff that's happening right now is poisoning the jury.
That was my question.
Right. And so it's going to be hard, because the first thing, like in voir dire, like jury selection, most likely one of the first, if not the first issues the attorney is going to talk about is like, hey, have you read anything about this case? What do you know about Blake? What do you know about Justin? What are your feelings about them? And, like, unless you're just getting, like, I don't know where this was filed and what the demographic pool is of the jury veneer, like the panel that's going to get pulled in for jury selection. But unless it's like, older people who don't really care about pop culture, we're just like, oh, who's Blake Lively? Who's Justin Baldoni? I don't know anything about this, But if you have a younger demographic,
how could you know?
They're going to know everything about it. And it's going to be hard to find an unbiased pool, which is also why, like, I go back again to media games, because that's their whole end game, is to try to win the court of public opinion. Because if the case does go to trial, everybody's already going to have an opinion. And so, people might say, oh, I can set my bias aside, I can be unbiased. But at the end of the day, it's very hard to do that. Yeah. And so, for me, I just think a lot of this has to do with, like, framing, in the media to win, in the court of public opinion. But also, kind of getting back to what we were talking about, I think there will probably come a time, maybe even sooner rather than later, that both sides are going to try to resolve the case in a confidential settlement, because, again, going back to the Johnny Depp Amber Heard trial, and in these trials, there's always a lot of dirty laundry that gets aired. And it's like, how much do you want to risk dirty laundry getting as well on either side? Because even if, let's say, everything Blake said is 100% true, I'm sure there's going to be stuff that's going to come out about her and, her conduct on the set, or stories about her on the set that Justin's attorneys are going to bring up that are not going to paint her in the best light, e.g. Ryan Reynolds being on set, all the time, being involved in some of these meetings. I think, allegations from the Baldoni team that Ryan Reynolds was kind of, whatever, like, not pleasant to deal with, right? In terms of how he
he's also in the suit in terms of the nice pool thing. Like, in Deadpool, he made a fictional character called Nice Pool, which is a very blatant characterization of Justin Baldoni. And I think there's like 4 or 5 cutscenes from the film that are openly mocking, like, this, like, hipster feminist guy that monetizes the women's movement. And, like, I know that Baldoni's team was trying to subpoena and, like, keep, I think, Disney who would be owning that. All of those like original scripts and
Mhm.
those pitches in order to establish like this is a mockery of me. How would that be? Like, does that fall under defamation, or does that kind of get away? Isn't there like a parody law that like you're allowed to?
I mean, that's what I was gonna say. Like, it's
Like, I don't know how
there's
you
the idea of
incorporate
like, you know, fair use,
Right.
which I don't know exactly how much that coincides with what we're talking about, but like there is artistic license, right, for like parody and stuff like that. Plus, like, did that character actually make it into one of the movies? So
I can't
would
imagine that
people
Disney
know-
also wouldn't.
But also, would people know? Would they see it and be like, "Oh, that's Justin Baldoni"?
I think in this context, absolutely.
But
I
when-
think without this context, no.
when did the movie come out? That Deadpool with that character, did it come out around the same time? This was
Yeah,
all
it was definitely
happening?
because there was jokes because within the Blake's allegations, she said that Justin was commenting on her weight, and there's a lot of stuff
I saw
around her
that,
weight. And so one of Nice Pool's lines is about commenting on pregnant women's weight. Like, there were very like direct
Okay.
parallels, but so I believe it was 2024 Deadpool and Wolverine. Yeah,
I think
2024.
yeah.
So it was like on the heels of this all happening.
Okay. I think even with that, there would be some sort of like fair use,
Right.
comedic license protection or something, or parody,
Yeah.
protection or something like that. But who knows? Like, that might also be one of the allegations of defamation in Baldoni's. Is like, oh, you created this whole character about me I'm sure that movie did well, right? Like a high grossing movie, disparaging my character or something like that. But again, like, to me, that's another reason why it would make sense at a certain point for both sides to come together with. So normally what happens in a situation like that is both sides will split the cost of a neutral third party mediator. In this case, it have to be somebody like high level who's probably familiar with the industry, who mediates these types of cases, because this isn't the first, high level dispute of this nature that's happened. So I'm sure there's mediators out there who specialize in these types of cases and situations. So you find that person who's the best of the best, go to a mediation and try to resolve the case short of trial, because at trial, all bets are off. And like,
Right.
the last thing I would want to be involved in as a celebrity is some sort of celebrity trial, because not only is it, yes, there's a risk of dirty laundry coming up, but it's like, it just drains your time, your energy. You got to go to trial. You got to go to court every day, be in court, eventually testify, put your faith in the hands of, 12 jurors, et cetera. Like, it's not a fun process, like, even for our clients, a lot of times it's not a fun process. Like, no one really relishes the fact as a client, like as a
Right.
plaintiff, there's not very many people who relish having to go to court every day, be in their mind judged by 12 people,
Yeah.
get on the stand and get cross-examined by the defense attorney. There's a judge sitting up on a dais, like, it's all very formal and like stark feeling, like, there's not a lot of people who are very keen on going to trial. Like, attorneys might be, because there's attorneys who love trying
Right.
cases, right? Because like, in a certain respect, trying a case is like your client's getting their day in court,
Right.
So you feel happy, proud, motivated,
Right.
going to trial, telling your client's story, like bringing those jurors together to render justice on behalf of your client. Like, as an attorney, that is very invigorating and inspiring. Like, it's why we do what we do. But at the same time, that's us. Like, the client might not have the same feeling, because it can be scary, honestly. So even all that aside, I just think trial is a massive, massive undertaking. Like, in a case like this, it's going to be very difficult to find, assuming they use 12 jurors as well in the state of New York, but it's going to be difficult to find 12 unbiased, impartial jurors who are going to listen to the evidence, completely unbiased and impartial, and just render a verdict solely based on the evidence, not based on any outside feelings, not based on any outside consultation with friends, family members, et cetera, because you're not supposed to talk to people.
Right.
When
Do you
you're
think
a
this
juror,
jury would be sequestered?
I mean, I think that's not the norm. I think it happened in the OJ case because the OJ case was such like a unique situation, and it lasted 9 months and they had to be sequestered for 9 months. So there's not a lot of judges that are going to relish sequestering people from their family because you have no phone.
Right.
You have no TV because you're not supposed to, look at outside media. This trial would probably take, not 9 months, but it's probably going to take some time. So I think typically judges just err on the side of instructing the jurors,
Right.
Not to talk about the case, not to read the news,
Right.
not to go on the computer and look up people, like all those types of admonishments.
Right.
But I think the judge would probably be loath to sequester the jurors.
Wow. So I guess to kind of start wrapping this up, we're far from the end of this.
Yeah.
There seems to be new things popping up every day. But I guess like if there's anything that, your average person can take from all of this, what might that be? I have some thoughts, but clearly. I guess, is there anything, especially when it comes to whether it's a workplace, obviously the defamation piece of it, I think is a little bit more difficult for most people to relate to, but like a workplace harassment case, of these extreme allegations, I mean, that's a long list. What, if anything, can people take from either reading about this or learning about this or seeing how it unfolds?
With respect to the hostile work environment allegations specifically, like I'll start there just because when I used to do employment law, we handled hostile work environment cases. So in California, the standard back then, I think it's still similar to this day. It might be a little different in New York, but it was basically the conduct occurring in the workplace was so outrageous as to make your ability to continue working there as an employee pretty much impossible. So if you were just to take that standard and apply it to this case and assume all of Blake's allegations are true, it would probably constitute that, right? Because this is pretty outrageous conduct. These are pretty outrageous.
I mean, the COVID one alone,
allegations. Yeah,
you can't do your job.
Yeah. So, kind of by analogy, if somebody in California, New York, or any state is experiencing that type of a workplace in their environment, hopefully first and foremost, you have an independent, HR type person that you can go to raise these concerns, because I would say that's one of the most important things you want to do is make sure that you alert the proper person. And I would say do it in writing.
Document.
Because if something happens and that employer does terminate you, and you never, took the proper steps, went to the proper channels, didn't document anything, now it's just going to be basically like he said, she said, and you're going to look like it's sour grapes and you're bringing up these things after the fact just because you got fired and there's no truth to them, And so everybody deserves to have a workplace they can come to where they feel safe, where they feel protected, where they feel if anything arises, not just, to a hostile work environment extent, but if something happens that, you feel unsafe or uncomfortable or something like that, you can go to somebody and voice those concerns and feel like those concerns are going to be heard and addressed. So, I would start there just in terms of the hostile work environment allegations and advice I would give to people in their workplace about how to handle such a situation, or again, hopefully there's someone you can go to, but again, I would put it in writing, make sure it's well documented, and then make sure that you're clear on what the next steps are going to be, right? Because if you just bring it to somebody and they're just like, okay, thank you for, telling me, I'll look into it. If you actually know like what the next steps are going to be, like, okay, this person, like, I'll do it. I'll do an investigation, and then I might not disclose the results of that investigation, but I'll bring you back and then we can talk about what remedial steps, if any, need to be taken or something like that. Just so like
there needs to be some level of action item.
What's that?
There needs to be some level of action item.
I mean, I would think so, because I think probably employees are worried about, once I tell this to somebody, like what's going to happen next? Like what's the next step in the process? Like if I'm complaining or talking about a specific person, raising a concern about a specific person, is that person going to find out I raise this concern about them? Because that's a valid concern too. Like you don't necessarily want somebody you work with to know that you've raised a concern about them, because you might be concerned about blowback from that person to you, or that person's friends to you, depending on like the office dynamic. So I think it's important to make sure that your concerns are going to be addressed, that you know the proper steps to take, the proper person to bring it to, and then what, if any, action is going to be taken in response to that complaint. Because if it's just like, I appreciate you raising this, I'll take it and just put it in a file and not take any steps. Like, that's important to know, right? And so oftentimes in companies, like the employee handbook will also spell out what the process is for, raising any sort of grievance, what's supposed to happen next, et cetera. But just for the average employee, I think it's important to make sure you document any concerns you have in writing. So then if something does happen, unfortunately, like there's some sort of adverse employment action, you can say, hey, I documented this complaint and then they fired me shortly thereafter, because now it looks like you got fired because you raised a concern about a hostile work environment. Right. With respect to her lawsuit in particular, again, I would say that if, all of these allegations are true, it, rises probably past the level of what constitutes a hostile work environment. Yeah. And then the next step is, what are her damages, because like in an employment context, I think that's something that's a little unique about this situation as well, is that they finished shooting the movie, right? The movie got released and made a whole bunch of money. In a standard employment law case, an employee might raise a concern about a hostile work environment and then get terminated. So now, the measure of damages is clear. Pain and suffering, emotional distress, loss of wages, et cetera. So for her suit, it might be, I haven't read the lawsuit, so I'll start there. It might be a little bit more uncertain what the measure of damages is for the fact that she got subjected to that hostile work environment, because ultimately she finished the movie, the movie went out, it made a bunch of money, whatever contract, like how she was to be compensated as a result of the movie, like maybe it was some back end deal, right? And she got all that money. So I think the measure of damages might more so be related to pain and suffering, right? Versus loss of income, because she might not have lost any income, but whatever she endured as a result of this, emotional distress, pain and suffering, that's probably going to constitute the bulk of her damages. Right.
And I believe there might be probably a defamation piece of hers as well, because of that press war that she's alleging he went on afterwards. And so that, probably there's like, I lost out on my hair care line and I lost out on whatever. The only other thing I wanted to just regroup on is like the uniqueness of this workplace in general. And like, I think for artists and filmmakers and I, the answer should never be don't make art or don't make things that are about a sensitive topic, but rather I think assume the worst can happen and then work back from there. Yeah. Right. Like how can you prevent stuff like this happening? Right. How can you take what happened here and make sure that a film that you're working on or are a part of, like maybe ask those questions and try to see if that film HR can't really be more of a thing, that people feel more safe, or maybe that's more union involvement, or maybe that's more intimacy coordinating being, a larger role or whatever that is. But I think those are the kind of pieces that I think are, not a positive takeaway, but an actionable takeaway.
I think because the industry is so piecemeal in terms of, independent contractors, and there's a lot of different like silos of different types of people who are involved, in the entertainment industry, in the film and TV industry, in the music industry. So, you have all these different independent contractors who kind of coalesce together for this project. And at the end of the day, there is no overarching system that you can go to for relief, right? I think that's what makes it very difficult. But I think at least thinking about how do we address this moving forward, thinking about it in earnest with the goal of coming up with, a system or a protocol or a solution, that's the best place to start, because there isn't really a lot of uniformity in terms of how do you seek redress in a situation like this? So I think, again, like you have to think about these things at the outset and just think about anything and everything under the sun and say, if this arises, how do we deal with this situation and the severity of the situation, and at least think about it and map it out, ideally in writing beforehand. So when this does arise, there's a process in place. I think, because there are so many disparate people involved, it makes it more difficult. Like, on any given set, it's not, just the actors, producers, directors. It's like, you have wardrobe, you have whatever, hairstylists, you have nail technicians. Like, I'm talking about like the entertainment industry, writ large, like music and, there's just so many different pieces that, again, coalesce for this one singular thing that it makes it a little bit more unwieldy to do. Because what if the person who made these allegations was like a nail technician or like a hairstylist, like wasn't someone as prominent as Blake Lively? Like, what redress would that person have or think he or she has? They might just think like, oh, there's nothing I could do. Like, just take Justin Baldoni out of it. But if it was like, Mr. Big on set, who's an actor, director, producer, like, what means do I have of redressing this situation as a quote unquote, lowly hairstylist? Like, I think there's probably too much of that goes on where people are just like, I don't know what to do, so I'm going to do nothing, and like throw their hands up in despair. So like, I would also be concerned about how do we assist those people and help those people feel like they have protections and they have clear guidance on what to do in these situations. But I think, film, TV, music, entertainment, those are just that, like, entertainment is one of those industries that historically hasn't necessarily had those concerns in mind. Like, it's an industry that's based on the stars and not based on the people around the stars. So when things happen to people around the stars, they kind of just get brushed under, swept under the rug. So I would also think about how can we ensure that everybody has equal access to some sort of system to assist them when things like this happens, and not just, a Blake Lively or somebody of that stature.
100%.
This podcast is brought to you by Adamson Addoot LLP. Hosted by Christopher Adamson. Produced by Lauren Henning and Chris Weigen. If you have thoughts or suggestions, email us at itspersonal@aa.law. The views, opinions, and statements expressed by guests on this podcast represent the personal perspectives of the individual speakers and do not constitute official positions of Adamson Addoot LLP or its attorneys, staff, or affiliates. Nothing discussed creates an attorney-client relationship, and the content is provided for general informational and educational purposes only. Always consult with a qualified attorney about your specific circumstances.